Hello everyone, welcome to our live event today, and welcome to Law in 5, where we discuss estate planning and business secrets and tips to help empower your business and your family. I'm Mark Peterson. I'm the owner of Snake River Law, your personal family and business lawyers. And today we're going to talk about 5 secrets to litigation-proof your small business. Before we get into that, if you want to talk to me further about this topic, you can give us a call at 208-406-9885, or you can schedule a meeting online at meeting.snakeriverlaw.com. If you have any questions during the live video, please just comment below. I have Felicia over here monitoring those comments, and so we'll get to those before the end of the video. So a couple preliminary definitions. Hopefully everybody's already aware of what all these words mean, but sometimes in the legal world we get used to using legal verbiage that isn't very common to most people. So a couple things. So first, I'll talk about litigation, and that's just the fancy word of being sued by someone or another entity. We'll also talk about judgment creditors, and that is somebody that has a judgment that they got in court that they're trying to collect money essentially from you or your business. And then we'll talk about corporate shield. And so that's the barrier that's formed when a corporation is properly run between your personal assets and the business assets and the business liabilities. So those are a couple, just some preliminary definitions to think about here. So litigation proofing your small business, why does that even matter? So one of the main reasons people form a small business is to have a liability shield between them and their personal assets. And it's essential that so if the business does something wrong or has a judgment against them or owes money, that there is a shield there that prevents that person or that company from jumping the business and attaching all of your personal assets. Most people, when they deal with a small business, they go to the state of Idaho or your local state, whatever that may be, and they file their articles of organization or their articles of incorporation with that state entity, like the Secretary of State here in Idaho. They go get their EIN number for tax purposes, but then they don't do anything else. And that's just where they stop. They have those 2 documents, but they don't ever do anything else besides that. And regretfully, in our society, there's lots of sue-happy people out there, and plenty of lawyers that are willing to support that. And so business owners that don't follow these 5 secrets that I'm going to give you today expose themselves on a personal level to the risk of having a person jump their corporate shield and attach their personal assets and take not only their business but their personal items as well. Also, the cost of litigation are really high. Hopefully none of you listening here today have had to go through that experience. But attorney's fees alone in litigation, are tens of thousands of dollars. So that doesn't even account for, having to pay off some type of judgment or the effect that would have on your business and on you as a person, on a personal level. So one of our goals here at Snake River Law is to help small businesses bridge that gap, to eliminate that risk of litigation and to litigation-proof their businesses. So here we go. Here are the 5 secrets to litigation-proof your small business. So the first one is no alter egos. Okay, my family, my kids especially, they like the superhero shows. The Clark Kents and the Superman and the Batman and Spider-Man. They like to watch those shows, and they're kind of a good example of this alter ego issue. Because as long as and I'll call it their corporate identity, so as long as Superman, Batman, and Spider-Man were only known as those individuals, and it was clear that that's who it was, and their true identities weren't known, they really didn't have a lot of ramification on their personal life. But as soon as their corporate identity, Batman, Superman, Spider-Man, merged with their personal identity of Clark Kent or Bruce Wayne or Peter Parker, and became nothing more, their corporate identity became nothing more than the alter ego of the person. The villains, so we'll take this in a corporate world, so ex-employees, other companies, unscrupulous lawyers, they use that information against them on a personal level. So they jumped past the corporate identity of Superman or Batman, and they went right after them on a personal level. And that's kind of what we're dealing with here. Businesses need a clear and distinct identity separate from their personal identity in order to preserve that corporate shield. If that gets blurred, and if people know now there's no distinction between those two, that's when those personal assets become subject to those corporate responsibilities. So how do we keep our company from not becoming our alter ego? So how do we keep those separate? So one of the important things is making sure all your contracts are in your business's name. Never put your contracts in your personal name. You want to sell or provide your services or your products as the business entity. You do not want to do that on a personal level. Make sure that all your lease agreements are in your business's name and not you as an individual. And you want to use your bank accounts in the business's name. You don't want to be using your personal bank accounts for business transactions. And then the last one is when you sign anything, you need to sign it under your role as the company. So for example, John Smith, president of whatever your business name is, or managing member of your LLC, however you have it structured. You want to be official in how you sign documentation and show that it is you acting as your role under that business entity. So that's the first one. No alter egos. We don't want to be blurring the lines between you as on a personal level and you as a company. So the next one is observe corporate formalities. And regretfully, this is the one where most small businesses fail to do anything with. And so what do I mean by corporate formalities? So companies should be doing the things I'm going to tell you right now. So these are the formalities, the things that they should be doing to show that they're taking it serious as a company, that they're doing what they need to as a company to show that they are actually a company and not just an alter ego of a person. So the first thing is to conduct annual meetings and special meetings, to actually go and do this. Even if you're a single member LLC, you still want to have your annual meetings and document that you did it and what was discussed, who was appointed as an officer and director. You want to document all that. Anytime there's any big decisions also that may affect how your company is operated or managed, you want to have a special meeting, you want to document it, you want to make sure all that paperwork is done. If you want to also issue, so if you're a corporation, you want to actually issue your stock certificates. If you're an LLC, to issue your member certificates. Show that you're taking it seriously, that you're identifying clearly who your members are and or your shareholder stockholders are if you're a corporation. You want to maintain your business records. The annual meetings, the membership certificates, all of that, that's part of that. But a lot of companies just fail to keep any type of record at all. So you want to maintain those business records, keep them up to date, keep them in a central location where you can find them easily. Businesses also, corporations or LLCs, so a corporation needs to have their bylaws, an LLC needs to have their operating agreement. And you need to make sure that you're actually following those documents when you're conducting business. So you need to reference them if you need to and make sure you're doing what you're supposed to. But following your operating agreement and bylaws are really important to keep that corporate shield in place. Make sure you have those documents too. If you don't have them, you need to get them. That's your starting point. Make sure to get that operating agreement in place or get your bylaws in place for your corporation. The last thing is just to appoint your officers and directors and keep that current on an annual basis. So you want to make sure that at your annual meeting, you're discussing that, you're reappointing people to those positions, either like in an LLC, your managing member is reappointed. In a corporation, make sure your officers, like your president, your secretary, those things are all addressed and done on an annual basis. Okay, so corporate formalities, observing those formalities is really important. If a court looks at this and says they're not doing anything to legitimize their business, they're more likely to jump that corporate shield and come after you on a personal level. So the next one is no commingling of funds. So where up here on the alter ego, we were commingling our personal and our corporate identity, this is talking about finances. So we don't want to be commingling any corporate and personal finances. So kind of going back to the superhero analogies here, I don't know if anybody saw the movie The Dark Knight with Batman. It was Christian Bale. Anyway, in that movie, the Joker convinces all the gangsters to kind of pool their money together and let him kind of take care of stuff, if you want to call it that. And what eventually happens to that money? The Joker puts it in a huge pile and he torches it. He burns it all up, okay? So merging their money and commingling their funds in that instance was not a very good idea. And it's the same for us as corporations. To preserve your corporate shield, you don't want to be those gangsters that think it's all right to merge everything together and to let, in that case, let the Joker control it. Because if everything's merged together, guess what? Courts will jump your corporate shield and they'll go after your personal assets. And then again, you have no separate distinction there and everything becomes exposed. And that's what we don't want to have happen. So how do we keep this from happening? What are the steps to do on this? So first is maintain a corporate bank account that is separate and distinct from any personal accounts. If they happen to be in the same bank, that's not what I'm talking about, but you don't want them to end up being the same account or have so many transactions back and forth where a court couldn't clearly distinguish which account is which. You also want to process all corporate payments, money, expenses, salaries, anything like that through that corporate account. You don't want to do any personal things through that account, but you want to make sure that the actual company is processing its own things through that corporate account. You never want to use the corporate account to pay for personal items or expenses. If on occasion you accidentally grab the wrong debit card or something like that, that's not what I'm talking about. But if you're consistently paying for a personal vehicle out of your corporate account, that's not going to go over well in a court. There's a big risk if you're doing that they would say that these funds have been commingled and we're going to disregard your corporate entity. You also don't want to use corporate cards for personal purchases. So can be somewhat tempting sometimes. You got a corporate card that maybe you just grab out of your wallet, you want to use it to pay for your vacation. Don't do that. Use your own personal cards to do that and keep those corporate cards separate from any of those personal transactions. If an owner needs money from the corporation, give them a draw. Don't let them use the corporate account to pay for their expenses. Go ahead and transfer money out to them, and then they can transfer that to their personal account, and then they can use that personal account to pay for those expenses. So that's number 3, is the no commingling of funds. Number 4, secret number 4, is manage your employees. So employees can be a real benefit to a company, but an ex-employee that's disgruntled could be a potential litigation nightmare for a company. So managing them correctly is really critical to minimize and to litigation proof your small business. So underneath that, some things you can do to help preserve that corporate shield and to litigation proof your small business would be proper employee classification. So there's 2 types, right? Employees or subcontractors. And if you misclassify an employee as a subcontractor, there's a lot of risk there, and it could be very costly mistake to you and your business. You could end up having to pay a lot of penalties and fines for that. So it's really important to do an employee audit and really put employees as employees. Don't treat people that should be employees as subcontractors, because that can come back and bite you. And there could be a lot of litigation issues revolving around that issue. So the other thing is to have non-compete agreements. So I hear a lot of times that people say, we can't have non-compete agreements anymore. They're not allowed under the law. And that's not true. You can have non-compete agreements, but they have to be narrowly construed to the employee and the situation. So that means you can't say that an employee can't work for 5 years in the same industry in the state of Idaho. That is too much time, too much area. So you have to really look at each employee and determine if a non-compete would apply to them. And based on their credentials and who they are, the longer the non-compete could be. So an office manager, you might be able to have a little bit longer non-compete on them than maybe like just a common employee, which probably would not have a non-compete attached to them. So you just have to look at their status, and then you have to narrowly construe that in time and area. But they are allowed, so that is something you can address, and that helps to litigation proof your business. If you have those in place, keep employees from taking information from you and going to a competitor. So the next one deals with those same things. So having non-disclosure agreements with your employees. Those are important so that they don't take your client information and then go to your competitor and give them all that information. Really simple documents, but they make a big difference when it comes to litigation. The other one is a confidentiality agreement that just says that they're not allowed to share your confidential information, which can include your processes, your intellectual property, also just your client information with a competitor or with anybody else. The benefit of those last two is, unlike a non-compete, they can have a much longer timeline attached to them. So that employee would be potentially liable for any of those disclosure or confidentiality issues over a much longer time frame than what a non-compete could cover. The last one is just have employee handbooks. An employee handbook is beneficial because it outlines your company culture, and it also sets out the expectations for employees. And so then if you come down to a situation where you have to discharge an employee for a violation or something like that, if it's clear in that employee handbook that that's a violation, they've signed off on that handbook as to the fact that they received it, they read it, they understood it, that reduces the risk to the business of them coming back and trying to sue them for a wrongful discharge or anything like that. So employee handbooks are really helpful. Okay, so number 4 is managing your employees. Number 5 is, see if I can write this low, is perform annual business checkups. Okay, and what I mean by this is to every year to sit down and actually go through these things, to think about it, to check up on the status of your business, update your records, update your business records, update your officers and directors, identify any corporate governance problems or issues that may have come up over the last year, and then identify and carry out a plan to actually resolve those issues, not just leave them hanging there, but to resolve them. And this is also really beneficial, at least what we found in our business, is it helps you to develop annual goals and objectives for your business to allow you to keep moving forward, to pivot to different directions or different services if you need to. So it's just really good from a planning perspective and a business longevity and looking into the future and not just being caught up in the day-to-day, but actually having a plan in place to grow and enhance and empower your business. So one of the things, so as a bonus today for listening to the video, we do have a business checkup worksheet that we can email to you. We'll also make it available on our website here in a little bit. But that business worksheet allows you to go through it and look through some compliance issues essentially and say, you know, where am I at with this? Am I compliant? Am I not? Do I need to work on this? Does this apply to me? So it's a really good resource to see where you're at, see where your weaknesses are, and then be able to make a plan to correct those weaknesses and to get that corporate shield nice and strong so that if there is ever a problem, you have that shield between your personal assets and any of your corporate liabilities. So we'll have that available to you. Also from now until March 31st, we are offering a $99 complete business checkup and review where we will actually go through that whole entire checklist with you and make an action plan with you about how to resolve some of those issues. So if you're interested in that, you can sign up by calling us on our phone number at 208-406-9885. You can also sign up on the meeting.snakeriverlaw.com online. And there's actually one of the options is a business checkup option, and you can sign up on there, and then we can help you go through all of that and identify any weaknesses and have a plan set out to correct those to make sure your corporate shield is going to be in place if anything ever does happen. Anyway, that's what we have today. We appreciate you listening, and we'll talk to you next time. And again, if you have any questions about that, just give us a contact, and we'll be happy to help you. Thanks.